I'm Teresa Phillips from Forster Moment. Welcome to today's program, Probate, Trust, and Guardianship Litigation. So first is our agenda for today. We're going to go over the role of a fiduciary, and there's three major areas that I just brought up: probate, trust, and guardianship. There's a different kind of fiduciary in each one. And then we're going to go into the nuts and bolts of probate litigation, then trust litigation, and then guardianship litigation. And while there's certainly some overlap with those different areas, we'll try to highlight the differences and some of the special things you should be looking for. And finally, we're going to go over the personal liability of fiduciaries. Even though fiduciaries generally are looking on behalf or acting on behalf and looking out for the behalf of another, there are certain circumstances where they can be subject to personal liability for conduct even arising out of the fiduciary role. First, let's take a look at the applicable law that we're going to be reviewing today and using in these materials. There's the Florida Probate Code, that's Chapter 733 of Florida Statutes. There's the Florida Trust Code, that's Chapter 736 of Florida Statutes. There's the Florida Guardianship Code, that's Chapter 744 of Florida Statutes. And then there's some special procedural rules and substantive rules called the probate rules is what they're commonly referred to, and they're rules 5.010 through 5.900. Now, don't let that title fool you. Probate rules also have some rules related to guardianship and generally the conducting of cases under either the probate code or the guardianship code. So first, let's take a look at the role of a fiduciary. What is a fiduciary? And generally speaking, it's someone who acts on behalf and in the best interest of another person. It's someone who owes a duty to that person that either arises as a matter of law or contract or by you taking action wherein you accepted that role. The hallmark of a fiduciary relationship is that you can't have any personal gain and that you have to be administering or doing something for the complete benefit of another party. So let's look at the ones that come up a lot in the kind of litigation we're talking about today. You have a personal representative. That's the personal representative is appointed by the court, and then the person that's in charge of an estate. If we're talking about a personal representative, we're in the probate court. We have someone who's died, and we're either probating their will or it's an intestate administration. Who has control over who's appointed? Primarily the court. The decedent can nominate someone in their will to serve. There's a statutory scheme as to preference if no one's nominated, but ultimately it's in the court's discretion as to who shall serve. Trustee is the fiduciary who's in charge of a trust, and in any of these that we talk about today, in theory, they can be co-personal representatives, there can be co-trustees, there can be two or more people that serve in co-roles. But for the most part, we'll just talk about them in the singular sense to make it as simple as possible. But trustee is almost always either named by the grantor of a trust or either has been selected by the process set forward in that trust document. A trust, as you may know, is just a document that's been created by a grantor wherein he grants or delivers property or rights or legal rights or proprietary rights or something to another entity called a trust, and someone has to serve as a trustee and oversee and administer that trust in the structure set up by the trust document or under Florida law. The trustee is usually named directly as the person, or there's a procedure set up to select a trustee in the document. As with all these fiduciaries, most of them can be filled by a person and or an entity, and it's not unusual to have a corporate trustee or professional trustee. Third is a guardian. A guardian is appointed by the court, and it's a person who looks after the property or the person itself of an incapacitated person, and that incapacity could come up by reason of age, of being underage, or by reason of mental or physical infirmity that creates a legal incapacity, meaning that you don't have the wherewithal to make sound financial and personal decisions about your care. And again, that's usually the same person, but it can be a different person. You can have a guardian of the person and a guardian of the property. Guardian of the person makes decisions about where you're going to live, your health care, those kind of things, the personal decisions, and the guardian of the property makes decisions relating to your finances. I've also named, just to help you out here, some different examples of fiduciaries you may see come up. They won't be the primary ones we're going to talk about in litigation, but for example, a conservator is someone who's like a guardian, but it's a guardian of a missing person who's neither been declared dead or incapacitated, but is missing. For example, a POW or something of that nature. A curator is essentially a temporary PR. They're always appointed by a court in a state matter before a personal representative can be decided upon. Administrator ad litem is again a court-appointed fiduciary. They're usually appointed to fulfill a specific function that the other fiduciary cannot, and especially in the context of a state. Sometimes a personal representative may not be able to do one of its functions or its duties because maybe that personal representative has a conflict of interest or something of that sort, and administrator ad litem may be appointed. Guardian ad litem is a specific subset of fiduciaries under Florida law, and they're appointed by courts to be the next friend to a minor, to a child. And it's a specific role that's been carved out for someone to look out for the interest of a child, not necessarily in an attorney legal role, but as their next friend to the court, and that they can report to the court on behalf of that child and look out for their interest in whatever legal proceedings that child is involved in. So now that we have a better understanding of the kind of fiduciaries out there, let's look a little bit more closer at the different roles. Oops. First, let's look at some special procedural rules that is going to be related anytime you're dealing with fiduciary litigation. First, be aware of Rule 5.080. That's the Florida probate rule. This rule essentially adopts the civil rules of civil procedure to be governing in all probate and guardianship related cases. And note that this doesn't necessarily have to be an adversarial proceeding, that the rules of civil procedure can still apply. And the only time they don't apply is if there's a specific probate or other rule that trumps them and is of the same subject matter. Rule 5.170, similarly, is the application of the rules of evidence in fiduciary litigations as in the context of probate and guardianship. Make sure you're familiar with rules 5.040 and 5.041 if you're going to be in the fiduciary litigation context, especially in estates. There's a creature called formal notice in estates that you won't see in other kind of civil litigation. And in some circumstances, you can notice folks by formal notice, which is different than personal service. It's sending something by certified mail with a special notice on it that they have so many days, usually 20, to respond and raise defenses. And it's sent by certified mail or other kind of express delivery where a signature is required. Be aware of Rule 5.065 is a notice of civil action. This is required to be filed by a personal representative or a guardianship anytime that personal representative or guardianship is named or aware of a civil action being filed that involves the estate or the guardianship matter. While that might not be, if you're involved in litigation, it might not necessarily be your duty to file it. It's still a good idea to make sure it gets filed, because why this is important is that the estate and guardianship matters cannot be closed when there's pending litigation. But if the court's not necessarily aware there's pending litigation, they can close and discharge the personal representative or something of that sort. So it's good to make sure that gets filed and that the personal representative or the guardian fulfills their duty to do that. Finally, always make sure you take a look at the local rules. Obviously, it's always good to know what a local judge's preferences are, but especially in the context of fiduciary litigation, you'll find local jurisdictions, different counties, they have different rules about the filing of fiduciary litigation. Some require things such as trust litigation or probate litigation or guardianship litigation to be filed in the same division as probate and trust and things of that sort. Some permit it to be filed in the general civil division. So knowing the local rules can be helpful in that regard. So now that we understand the role of fiduciary, now we've taken a look at some special rules that might apply to you if you're a fiduciary involved in litigation or you're involved in litigation against a fiduciary. Let's move forward and start looking at some of this litigation specifically and what's involved. The first area is probate litigation, and there's two very broad areas where you're going to be involved in probate litigation. There's some litigation that arises before the appointment of the personal representative, or essentially can arise before the appointment of a personal representative, and they involve matters that really have nothing to do with anything the personal representative has done. And then there's the second part we're going to look at is more along the lines of when a personal representative can expect to be involved in litigation. So first, let's look at pre-appointment of personal representative litigation. The first most common example is going to be your will validity contest. Section 736.0207 Florida statute is the rule that in the statute that applies to actions to contest the validity of the will. And it reiterates the contestant of the will has the burden to prove invalidity. And you show invalidity usually there's three broad categories of how you can show that a will is invalid. The first is failure to comply with formal execution requirements. Now, it's a misnomer to believe that you need two witnesses and a notary to make a will valid. Actually, to make the will valid, you just need the two witnesses. But the two witnesses must be in the presence of the testator, the person making and signing the will, and in the presence of each other. They all three have to be in the same presence when they sign to make it valid. And in the past, not so much in recent years, but there's certainly case law out there about witnesses not being in the same room at the same time, someone coming in and someone making the mistake of stepping out before the other one finishes signing the other second witness. So that can be a ripe area for contesting the validity, especially if maybe it wasn't done with an attorney that might have oversaw the formal execution. Now, why sometimes people are confused about the notary there is a way to self-prove an affidavit, which is essentially an affidavit that of course you need a notary to take the oath of the witnesses and the testator and have them sign an affidavit, essentially saying that we did execute it right, we were all here. And that can do what they say, self-proven. That means you don't have to have a witness there to say, yes, we were all here and we all did it correctly. You can use that affidavit as proof that it was done correctly. But sometimes people confuse that, thinking that affidavit is necessary to make the will itself valid, and that's not correct. Now, we have a little wrinkle on this one, or certainly something new. As of January 1st, 2020, a new law took effect that now allows the electronic signatures of wills, and that they can be electronically witnessed and signed. And that meaning that via communication, video communication, that sort of thing, witnesses can appear, observe each other, observe the testator signing, and they can place their electronic signatures on the documents, and even the notary can do that as well as part of the affidavit. So it's expanded that idea of what's it mean to be present. For purposes now under the statute, being present includes seeing each other through some kind of video communications. And that new statute has a whole section of that relates to what kind of procedures you have to jump through to be qualified to do that as a notary and have electronic signatures attached. But I encourage you to take a look at it. This is a prediction on my part, but I think that will be a future hotbed of litigation in probate or other documents, because I think by its very nature, it's new, so people will probably get it wrong sometimes. And two, it certainly can create new evidentiary issues as to were people really present the whole time and things like that. So just be aware of that. If you're looking to contest a will or looking to examine to see if a will can be contested, that's always the first thing you want to look at. Was it executed with the formal requirements, i.e. two witnesses who signed, witnessed the grantor signing, and signed in the grantor's presence, in the presence of each other. The second reason that you might see litigation arise that has nothing to do with the personal representative is that the settlor was incapacitated. The testator, the person who made the will, just wasn't of sound mind at the time that they made the will. And per section 732.051 Florida statutes, you must be of sound mind to make a valid will. This is always an evidentiary battle. It doesn't, unless they've been declared incapacitated, there's going to be a strong evidentiary hill to get over to prove that person at the time they signed the will was incapacitated. It's not hard to find evidence of perhaps people being infirmed or suffering dementia or things of that sort, maybe because of due to age at the time, around the time the will was signed. But the burden in any kind of will contest is to prove at the time they signed the will, the moment they signed the will, were they incapacitated or were they having a lucid moment. And again, that's going to come down to probably the witnesses who were there and their testimony that they can give. 3, fraud, duress, mistake, or undue influence can be a reason to set aside a will. These are buzzwords you hear, and you hear the term carpenter factors. If you're involved in any kind of probate litigation for any kind of fiduciary litigation for an amount of time, you're going to come across the carpenter case and the carpenter factors, and also refer to Section 733107 Florida statutes. For the Carpenter case was a Florida Supreme Court case that came out in 1971, and in that opinion, the court listed 7 basic factors or badges of fraud they were looking at, or badges or indicators that fraud, duress, mistake, or undue influence may have been involved. Again, this is usually used for undue influence, but it can be badges associated with anything that can make the will invalid, because it's not the will of the person. It was actually someone else's will being exerted on the testator at the time that it was signed. And they listed 7 things that they look at, and they're commonly referred to as the carpenter factors. That one is the presence of the beneficiary at the execution of the will. Number 2, presence of the beneficiary at times when testator expressed a desire to make the will. Number 3, recommendation by the beneficiary of using a certain attorney to draw up the will. Number 4, knowledge of the contents of the will by the beneficiary prior to its execution. Number 5, giving instructions on preparation of the will by the beneficiary to the attorney that's drawn up the will. Number 6, securing of witnesses to the will by the beneficiary. And number 7, safekeeping the will by the beneficiary after it's been executed. Now, since Carpenter, there's some other courts and have added to this list. And Carpenter noted, the court there noted that there's other factors that can indicate undue influence or fraud or something of that sort. And from the case law since then, we've come up with 3 more that's commonly referred to as part of these Carpenter factors. One is isolating the testator and disparaging family members. Another one's inequality of mental acuity between the decedent and the beneficiary. And number 10, reasonableness of the trust provision. So with the original 7 and these 3, we now have 10 commonly known Carpenter factors. And to put this in context, if you have someone that comes in and tells you they have some concerns about a will, these are some of the factual questions you should ask, and to the extent they know. If they're coming in to see you and they think, that there's a certain beneficiary under the will or someone who benefited under the will that, that I think had undue influence over the testator, and because of that, I lost my position in the will, or I lost my position in inheriting under intestate. These are the kind of factors you would ask, well, who drew up the will, whose attorney was that, who sought out that attorney, who was present, was there, was this beneficiary in the room, and you can understand why these would be relevant. If someone really doesn't want to leave something to, maybe they don't want to really disinherit one child in favor of another, but that one child has a lot of influence on them and they put a lot of pressure on them, and they're sitting in a room and that person's sitting across the way there, that they're going to naturally feel pressure to sign that will, even if maybe deep down it's not what they really want. And especially if you start coupling this with things like isolating the testator from other family members, disparaging other family members, and then especially if it's maybe come to a point where the parent has their mental faculties aren't to the standard they once were, and maybe the other person's just a little bit better at manipulating and controlling a situation than that person. Maybe they're not on par anymore due to physical or mental infirmities that have happened due to health or age. And then the reasonableness of the trust provision, even if all those things happen, but at the end of the day, the provision, either the trust or the will provision is, at the end of the day, it's just all three of my kids get a third. The court's probably not be too disturbed by that, because normally that's what most people would want. So that can be an important factor. The carpenter emphasized that not one factor means more than other, that they're to be all considered, all the circumstances should be considered, but that these are things that the court should look at and weigh and determine if it was the testator's own will that was being submitted on that document signed, or were they really being influenced unduly by another person. That is a fraught area for probate litigation, and in my experience, that's the leading reason cited in will contests. Another cause of action you should be aware of that is available to someone who believes that they've been aggrieved and left out of a will or something because of the wrongful conduct of another. It's called tortious interference with an inheritance. It's a relatively new cause of action. There's not a lot of case law, but there's some out there about it, and it's kind of related to tortious interference with contracts, but it's in the context of an inheritance or bequest that you were to receive, a gift you were to receive. And in the typical scenario, you have a loved one who was left out of the will, even though they had every expectation of being in that will, and it was because of the tortious conduct of a third party. What was that tortious conduct? Maybe that third party defamed you, told lies about you. Maybe they did something that would be fraudulent or things like that convinced that testator to leave you out. Maybe they switched, maybe they fooled the testator into signing a document, something like that. And it doesn't have to necessarily be the will itself. In this case, you could be talking about maybe there was a payable upon death bank account and they switched that, switch the beneficiary on that, or switch the titling to that based on some kind of tortious conduct of a third party. And you can sue the third party based because you've lost that expectation of a gift, not just a bequest in a will or an inheritance. Now, there's one special thing you have to remember about this particular cause of action. It's only available, you have to plead and prove that there's no other adequate alternative remedy available in probate court. So this one's not necessarily available until you first go through a will contest or any kind of remedy you might have through the probate court. Then and only then can you go forward with a tortious interference claim. So remember that if a third party conduct was what was driving this, there may be a way under undue influence or a will contest or something like that that can be sufficient, and you would be forced to try that and go through that process before moving on to a tortious interference claim. Let's look at common pitfalls that lead to litigation for a personal representative or PR. The first one I've listed here are creditor claims, and right under that I have independent creditor actions, and I'm going to discuss those jointly because they're related. One of the duties that a personal representative has is to pay the debts of an estate. The creditor claims that are made in the estate, there's a procedure set forth in the Florida statute. The personal representative has to review those, and if they determine they're valid, they pay them. But if they determine they may not be invalid or they have reason to doubt the validity or the amount, they have to do what's called an objection. And there's a procedure for this. It's a formal document that you file and serve. And it's filed with a notice that says that those creditors, then, if they really want to pursue this, if they think they have a valid action, they have to bring a third-party claim within 30 days. And those are called independent actions. And they're usually filed in just civil court. They're just essentially to get paid on a contract or get a bill paid or help, an ambulance bill or whatever bill is that they're taking dispute with. So by definition, the personal representative gets named as a party in these claims. And they may have to defend those. They may have to make decisions about, the cost of defending those, settling those, that kind of thing. And the personal representatives are given a lot of discretion in settlements and things of that sort, making business decisions and what's the smart decision to help the estate. And you can always have those approved by the probate court as well when you have settlements of those kind of claims. Another area the personal representative may find themselves involved in litigation is related to tax disputes. Now, this can be because the decedent themselves were in arrearages to the tax reporting authorities, such as the IRS or your local state agency at the time they died, and they could be just ongoing disputes. And now instead of having a claim against the personal, the individual, now the IRS is moving and making a claim against the estate. And you may find yourself having to defend such actions in tax court and things of that sort on behalf of the estate. Now, the next thing I've listed there is GST tax. GST tax is generation skipping tax. And I bring this one up as a special area because I think this one's a real pitfall for personal representatives. Because unlike the other tax disputes that could be arising from the decedent's conduct, GST tax disputes is one of those that could arise from the personal representative's conduct. Now, there are certain tax decisions that the personal representative is going to have to make if it's a taxable estate or an estate that has to file income tax returns or a 706 estate tax return. And if they make the wrong decisions or they act, in a breach of their fiduciary duty, they can be sued by the beneficiaries or the creditors of the estate who may be harmed because they made a bad decision. Now, usually personal representatives are using professionals, accountants, and attorneys to help them with these, but and they may have some, and may be able to reasonably rely upon those, but ultimately they make some decisions, and some decisions have a little bit more discretion than others, and might not be the clear right answer might not be as clear as in some cases. And GST tax can be one of those. I don't want to get into a lengthy discussion about GST tax, but it's just for the purpose of our discussion today, just understand it's a very complicated scenario where you're going to have taxes owed, and oftentimes if the documents do not spell out the will document, trust document, what have you, the personal representative has to elect and allocate as to what property the tax is going to be paid from. So you have tax that's being created because something in the will or somewhere along the way is being left or was gifted to generations that have so many years between them, like grandchildren. This is what they call a second generation. So there's an extra tax, but you have to allocate where it's going to be paid from, and you may be allocating it from gifts that are going to not the grandchildren, to other parties who are going to be upset that their gifts have essentially been reduced because they had to pay taxes related to a gift that was made to someone else. And once those allocations are made, they're irrevocable in that context. So this is especially one area, all tax areas, fiduciaries should be getting good legal and tax advice. But this is one area that is essential. It's easy because of so much discretion, so much complicated procedures to follow and figuring out where the tax should be allocated from. This is one of those areas where you definitely want to make sure you're relying upon professional advice, so that the one beneficiary who ends up taking the burden of the tax, who's not going to be happy, has less chance of arguing that you breached your fiduciary duty to that person. Another common area is the elective share. That's section 732-.2075 Florida statutes. It's a very complicated statute too. It's very long. You could have a whole hour just on elective share. But for simplification and purposes of our discussion today, elective share is basically a statute that says you have to leave your spouse at least 30% of your entire estate. And that means not just your probate estate, but anything you owned in trust and any joint property and things of that. Pretty much everything you had an interest in at the time of your death, at least 30% of that has to end up in your spouse's hands by whatever mechanisms you came up with, your wills or what have you. And if it doesn't, they can take an elective share, and the court comes back and restructures the way the personal representative will end up getting 30%. But what happens is it's actually the personal representative's duty, first of all, to try to comply with the elective share. And if you're ever hit with one of these and you're representing that personal representative, or you're representing the spouse who made the elective share, you'll take a closer look at that statute, and you'll see there's a lot of different ways you can value things. There's a lot of different ways that you can decide whose asset you're going to take it away from to pay it. There is a structure set forth, but sometimes it's not as clear as you would think, depending on the circumstances. So as you can imagine, after you've told someone that they thought they were going to get, all the brokerage accounts, but then you have to go back and tell them, no, I have to take 20% of that back because I have to put it in the elective share. That person's not going to be happy. And oftentimes the spouse, even though you've gone out of your way to make sure things are valued and that you can get them 30%, not $1 more, not $1 less, sometimes they're not happy. So as you can imagine, litigation sometimes results from elective share issues. Now, we've alluded to it, but let's get to breach of fiduciary duty. Now that can sometimes be the one that the fiduciary is most scared to see, a breach of fiduciary duty, because it implies, unlike these other disputes that we've talked about, where the dispute's not really arising particularly because of the personal representative's intentional conduct or intentional wrongdoing. Breach of fiduciary duty by its definition suggests wrongdoing, and in most cases intentional wrongdoing by the personal representative. And this is usually interested party taking issue with some decision the personal representative has made, which has resulted in a loss to the estate. Personal representative, like most fiduciary duties, or most fiduciaries, has a wealth of duties that they owe to the estate. They have the duty of loyalty, a duty to avoid conflicts of interest, a duty not to self-deal, and they have, in a somewhat unique context, they have a duty both to creditors and beneficiaries of the estate. Now, if you think about that for a moment, that's almost inherently conflicting. Every dollar you give a creditor of the estate means one less dollar for the beneficiary. And trying to balance those, trying to determine who has valid claims, how much those claims should be paid, that can cause a natural tension between those two parties that you owe a duty to. So you can certainly see scenarios where no matter what decision the PR makes, one party's going to be harmed and they may be inclined to scream breach of fiduciary duty afterwards. But in my experience, breach of fiduciary duty claims arise out of two scenarios. And one is failing to account to the beneficiaries and keep them informed. And I should say failure to fully and properly account and keep them informed. You have a general duty to keep people informed and answer, questions related to the estate. Interested parties may pose to you. You have a duty to account at the end, and sometimes a judge will order an interim accounting if it's been a while. It's presumed most estates will close within a year, so usually not more than a final accounting is required. But with all that, even the informing, just informal information that you may provide, it's important to make sure it's full and it's complete and it's accurate, and that you've taken monies and you've accounted for monies that have only been used for proper estate purposes, and that you haven't mixed this account with your own personal account, or you haven't failed to put down all these expenses that you paid for yourself, or that you took a trip to go look at some property for the estate and you took your whole family on that trip and paid for it from the estate. Those kind of things are going to be areas that can lead to a breach of fiduciary duty claim. Another area where it comes about is a failure to determine the beneficiaries and distribute in accordance with the will or applicable law. Now, that may seem simple on its face, but sometimes wills aren't as clear as you would think. Sometimes it's not as clear as to who gets what. You have these odd provisions sometimes that talk about, I currently live in a home at so-and-so, and at the time of my death, I want my daughter to have that home. Well, it may have some language that may suggest that that's the only home they have. But what if they had since signing that will, they sold that home and bought a new one, and maybe it's not as clear. Does she actually get the new house, or is that irrelevant now? And so sometimes it's not as clear as you would think in the will, and sometimes relationships aren't as clear as you would think. If you're dealing under the intestate statute, someone says they're a sister or child, and some people say they're not, and getting records and things of that sort. So my recommendation on this is always, if there's any doubt, if there's any need for clarification whatsoever, file a petition to determine beneficiaries, and the court will read the will, will review the evidence of paternity or what have you, or the relationship, whatever issue is being caused, and the court can make the ultimate determination, and that can get the personal representative off the hook in that respect. I do encourage a personal representative to take advantage of getting court permission to do anything that they think that might be fraught with dispute later on. While the personal representative is giving broad discretion to take steps without court intervention, it doesn't mean that you can't always go get court protection, notice all the relevant parties, and have the dispute settled before you even make the decision, to avoid litigation later on. And finally, I also recommend good communication. My experience with beneficiaries or creditors, for that extent, are more likely to be suspicious and be upset to the point of wanting to litigate when something hits them out of the blue. Keeping them informed through the administration process, advising them that, the tax bill was higher than expected. We've had a lot of accounting bills. We've had some creditors that's come forward we didn't, recognize. Keeping them informed of those kind of things kind of makes it a little bit easier when they get the final check that may have been less than they had initially anticipated, and probably helps to have a relationship of trust than if you never spoke to them and all they heard was that you're their personal representative, and then 1 year later they get a check that's half of what in their mind they thought they were going to get. So those are my two secrets of trying to avoid breach of fiduciary duty litigation: is good communication throughout the process, at least as best as you can under the circumstances, and two, use the avenue of going to the court and getting the court to approve decisions that you make that may have some discretion in them that could be called into question later on. Let's turn our attention to trust litigation. Now, some of the same principles that we just went through with probate litigation is going to apply in trust litigation for a number of reasons, and we'll get into that. But if you hear some similar themes, I want to go ahead and warn you, you may hear some of the exact same verbiage or some of the same standards that we've just discussed. But let's first get back to what we talked about in the beginning when I introduced you to what a trustee is. A trust is a document that an individual creates, and they essentially deliver, bequest, give, transfer interest in property or property outright to this trust, and now going forward it's held in the name of the trust, and it's to be held, managed, and distributed in accordance with whatever that trust document says. They oftentimes have provisions in them that are of bequest kind of nature, a lot like a will, and to the extent they do, they're required to be executed with the formalities of a will. There's two types of basic trust in very general terms. You have your revocable trust. Revocable trusts are those that can be revoked at any time. They're really, usually the grantor, the person who made the trust, is kept complete control. They're usually the lifetime beneficiary of that trust. They're usually the trustee, and they have complete discretion over that trust. That's usually you're dealing with the same person in all those roles. So it doesn't really lend itself to trust litigation. Usually, someone's not going to sue themselves. So where you really get into usually the meat of trust litigation is an irrevocable trust. And anytime one's after death, it's irrevocable by nature. You can create a trust that's irrevocable by its own terms, but that's rare for people to do during their lifetime. And by definition, in these kind of trusts, you have party other than the grantor that's now serving in a trustee role. And subject to the specific terms of the trustee usually has a duty to a varying number of parties. And many of these parties have conflicting interests. For example, your typical trust is set up. I set up a trust during my lifetime, all my properties in this trust, but I have complete control over it. Upon my death, my sister will be my trustee, and during the lifetime of my children, she will distribute all the income to my children and has some discretion to distribute principal. Then upon their respective death, she'll leave it outright to their children, which would be my grandchildren. That's a typical scenario that you'll see in any trust. Well, if my sister's a trustee, she's taken over my trust upon my death, she now has duties to pay my debts to potential creditors, including the PR of the estate who may make demand for payment of my debts. She has a duty to my children, especially during their lifetime, but she also has a duty to those future beneficiaries to make sure she doesn't abuse her discretion in making distributions. Otherwise, those future beneficiaries, i.e. my grandchildren, may not get their fair share that was anticipated. So she's might be forced one day to make a decision on a request made by maybe a child that wants a part of the principal and that she thinks might be more than I would want based on my trust document. And she has to make a decision, because if she makes the wrong decision, she may harm the future beneficiary, who would be my grandchild in that scenario. So I give you that scenario so now that you're seeing the picture of the players that would be involved in what might lead to litigation. So let's look at some common litigation pitfalls for trustees. One of the first ones is failing to comply with statutory notice requirements. There's statutes that require you to give notice to beneficiaries and people with vested interest in a trust, and you have to do it within so many days, actually 60 days of the acceptance of trust. And that section I'm referring to is section 736.0813 Florida statutes. And so many people fail to comply with this. You have to give a specific notice. There's specific requirements in it. It's not very complicated. It's just overlooked. And the trustee must give notice to all the beneficiaries that there is a trust, that they're a beneficiary, that this is the trustee, this is how you can contact the trustee, and inform them of their right to accountings, and inform them that if you have counsel, that counsel is only looking out for the trustee's interests and does not represent them as individual beneficiaries. You also have to provide a copy of the trust or advise them that they can request a copy of the trust anytime they want. So if you fail to do that, you can be responsible for any damages arising from your failure to do that. And so you want to start out good right off the bat and make sure you get those notices out. Conversely, if you're representing a beneficiary who didn't get those notices, you may already start out with a good case if you want to start in litigation that they failed to comply with statutory notices. Another area that can be a pitfall for trustees is when they have to apply principal and income and then maybe evade principal. And that scenario I gave you is a common scenario. There's usually lifetime beneficiaries and then future beneficiaries. And when you have that, while it may be prudent and maybe even required to distribute all the income, you're going to have leftover principal, and usually there's some language in there that says for health, maintenance, support, education, principal should be invaded at the trustee's discretion. But what if the education is, a trip to France to study art, or, a trip around Asia because they want to further their, experiences for their art career. There's some things that's just going to be discretionary, and there's going to be certain things that if other beneficiaries have an interest in that principal, if it's not used, they may be upset if you use it. So you first have to make sure you're applying principal and income correctly and under the terms of the trust document and or the trust code if there's no provisions in the document. And then you have to carefully consider that standard or any standard set forth in the documents when it comes to invading principal. And it's probably not a bad idea to get legal and accounting advice and tax advice before making final decisions. Next area, accounting to all interested persons with a vested interest. Trustees are required to account yearly, and this can be waived by the interested parties. I have my own reasons for thinking it's a good idea to do it, and we'll get more into those later on when we get to a different section on trying to limit actions against the trustee. But at a very minimum, you should be prepared, keep good records, and be prepared to account, do formal accountings every year, like I said, unless waived. Trust validity contest. This is going to mirror everything we just talked about in the probate litigation area. If you want to go after the validity of a trust, the three main areas are: first, you cite to the fact that it doesn't comply with formal execution. Now, normally a trust only needs a signature to be valid, but if it's got testamentary aspects, if it's bequesting things, leaving things upon death, things that would mimic what you would usually find in a will, then it has to be signed with the formalities of that of a will in order for those provisions to be valid. So in that case, you're looking for two witnesses signing in the presence of each other and the presence of the testator. And again, it's the same application that we talked about earlier about self-proving being an option too to help prove that up. Incapacity of a settlor. Just like making a will, settlor of a trust has to have legal capacity. Again, if you want to attack that, you have to be able to put on evidence that the person was incapacitated. Unless they've been declared legally incapacitated, it's presumed everybody has capacity and can make a trust or a will. So that burden will always be on the person who's trying to prove the incapacity, and they will have to be proven that those circumstances at the time the trust was signed. Number 3, fraud, duress, mistake, or undue influence. And again, I cite to the Carpenter factors that we went through pretty much in detail earlier, but they're just as applicable to a trust document. If someone was, unduly influenced to sign the trust, they had an attorney selected by the person who's exerting the undue influence to do it, and there was all those factors that we went through, or most of those factors there, the trust is subject to being set aside, just like a will would in those circumstances. Let's look at breach of duty, a trustee's duty. And the duties arise under the Florida Trust Code, lays out specific duties, and the common law provides many of them. And I try to put the 5 big ones there. The first one is the duty to inform an account. It's very similar to the duty we talked about in probate, and it starts with your statutory notice. You have a duty of loyalty, and you have a duty to look out for the best interest of the trust and the parties of the trust as opposed to your own. It specifically provides, that even if the trust instrument doesn't, the law provides that, you have this duty. Sometimes, the trust instrument will excuse you from what might sometimes be a conflict of interest. If, for example, there's a small business, family-owned company, and the trust owns part of it, and you personally own part of it, maybe the trust excuses you from that conflict of interest that the law might find that if you have your own interest in the company and you're also controlling that interest for other parties, there may be an inherent conflict there. Normally, I think the statute duty of loyalty would find that to be a conflict of interest, but perhaps the person who created that trust and selected you as trustee may excuse that under the trust document because they would already be aware of those circumstances. You have a duty to protect assets. That's almost any fiduciary who has control over assets has that duty. That means insuring them. That means physically, making sure that they're secure. If that means putting them in some kind of air-conditioned storage unit, or if that means putting them in a safe if the circumstances dictate, you have to protect assets. And you also have to think of it in the context of intangible assets, such as brokerage, stock, things like that. You need a good advisor. You need to be prudent, and you need to be wise in what you do to protect against risk of loss and those kind of things. Having good advisors goes a long way. You have a duty of impartiality. Again, that's related to loyalty and conflict of interest. You can't get yourself in a position where you're making a decision that you might personally benefit from, or it might work to the detriment of someone else that maybe that you have an adversarial relationship with. Your decision should be based solely on the documents and the law and adhering to what the settler wanted. You have a duty to distribute the trust income. This is essentially an accounting function, but the most important part of it is to make sure you distribute it to the right parties and that you've paid all the debts and you're distributing what's truly the trust income. What if someone breaches one of these duties? What are the remedies? There's statutory remedies per section 736.1001, subsection 2, Florida statutes. You can compel the trustee to perform the trustee's duties. You can enjoin the trustee from committing a breach of the trust. If they're holding on to the income and not distributing it, you can have an injunction that requires them to stop doing that and to distribute. Or in the case of enjoining, stop them from doing conduct. Maybe they've taken something that belongs to the trust, they've taken it home and they're using it, and the court can maybe using a car that belongs to the trust, and the court can say no, you can't use that car anymore. It belongs to the trust and can only be used for trust-related activities. Number 3, compel the trustee to redress a breach of trust by paying money or restoring property or by other means. And again, this is if a trustee has taken money out to pay for maybe a child to go on a trip with them that was trust related. Maybe the court says, no, you shouldn't have done that. You've got to put the $300 back for that ticket. You can order a trustee to account if they're in breach of their annual accounting. If you can show reason, sometimes judges will order interim accountings, or at least order them to supply financial information. You can ask to have a special fiduciary appointed to take possession of trust party and administer the trust. If there's a certain area that's not going to be resolved, there's always going to be a duty or going to be like a conflict of interest, something like that, then the court can just say we're going to have a special fiduciary duty in this case. And ultimately, if it rises to the level, you can certainly ask for a trustee to be removed if their conduct has gone to the point where the court doesn't believe they can go forward in good faith and adhere to their duties. Now, these are just the statutory ones. There's common law, remedies too. There's also remedies that can be provided or limited in the trust document itself. Sometimes you'll see that they'll have things if, for example, like I gave before, they can say that, acting on behalf of a company that they own interest in and the trust does will not be a breach of fiduciary duty by the trustee under this trust. You can change some of these things and thereby limit the remedies. You can also have add remedies. You could add a remedy where if enough beneficiaries are unhappy with the trustee or believe the trustee's not conducting as they should, maybe by a vote of so many, they can be removed and replaced. So you always have that option to create alternative remedies for these kind of situations if you so choose in your documents. Moving along with the statutory items, I thought we touched on suspend the trustee and then remove the trustee. There's also reduce or deny compensation to the trustee. If the trustee has just not done done what they were supposed to do, it's going to be a little disingenuous to come and ask for compensation. And if you ask the court to reduce or deny them compensation, you may get it. Subject to Section 736.1016, you can void an act of the trustee, impose lien or constructive trust on trust property, or trace trust property wrongfully disposed of, and recover the property or the proceeds. This comes up a lot in the case of a trustee doing an inside sale to maybe a family member or a friend and giving them a good deal, and then you go back and you try to undo it. Where it doesn't work is when it's been an true innocent third-party purchaser or something like that. Every now and then it comes into play when a trustee just gives away or donates property, not recognizing that it really was valuable or had some kind of value and didn't get the beneficiary's permission, and then you try to go recover it. And then number 10, there's a order any other appropriate relief, always the catch-all there. Let's talk about limitations on a trustee's right to use trust monies for fees. This I think, is an underused provision in the trust code. Unlike in some of the other provisions with personal representatives and stuff and guardians that we'll look at, in the context of a trust, there's a statutory provision, 736.0802, subsection 10, Florida statutes. If you're suing the trustee for breach of trust, it's an advantage to them to be able to use trust funds to pay their attorney's fees to that litigation. And even if they're ultimately found liable and they're not allowed to get their attorney's fees, they've had the advantage of having the use of those attorney's fees through the litigation. With this mechanism, you can put in a notice of intent, and you identify the judicial proceedings, and what you're essentially doing is you're asking for a hearing for the court to determine that the trustee shall not use the trust proceeds to pay their fees going forward. And you can look through the statute in the items here. But what you will see is that if the court determines you've laid out a pretty good case for breach of conduct, the court may compel the trustee to just pay their own trustee fees going forward. And if they've already used some of it to pay their fees, the court can compel them to repay that. Number 5 here, just take a look at it. I think that kind of gives you an idea of what the standard is. The court shall deny the motion unless it finds a reasonable basis to conclude that there has been a breach of trust. If the court finds there is a reasonable basis to conclude there has been a breach of trust, the court may still deny the motion if it finds good cause to do so. So I think it's definitely showing you that you have the burden to convince the judge that you're really likely to win this, and that it would really be wrongful to allow the trustee the benefit of the doubt to use those monies. Another area of trust litigation is judicial modification, and this can actually be where the beneficiaries and the trustees are on the same side. And I've listed out the different mechanisms under the statutory system, and under different scenarios, you can ask the judge to essentially change the terms. And for example, the first one, Section 736.04115, it provides a means for any interested party to seek judicial modification of a trust when it's in the best interest of the beneficiaries of the trust. And if you have the beneficiaries agreeing and it doesn't conflict completely with the purpose of the trust, and a lot of times you will get that modification. There's the next section, 736.04113, Florida statute provides a means of modification when all the interested parties are in agreement and the proposed modification is not inconsistent with the seller's purpose. Very similar to the first one here, if you have all agreement, it's even easier because you just cite to the statute. The first one, you still have to prove the best interest of the beneficiaries. Here, as long as everyone agrees, you don't have to show it's in the best interest of the beneficiaries of the trust. Section 736.04114 Florida statutes can be used to modify or construe provisions which are needed to assist in maximizing federal tax benefits. This comes into place when there's been a change in the tax code or something that wasn't anticipated, And if you make a simple modification, a big savings can be made for tax purposes. This has been used in the past when there's been unexpected change in the trust documents were created, 10 or 20 years before. And then 736.0414 codifies what actually was in the common law. A trust can become uneconomical, and if you can convince the court of that, they'll essentially just dissolve the trust. And then you can reform or change by interested party agreements when truly all the interested parties, including future interested parties, agree. You can make changes. Limitation on proceedings against trustees with disclosure. I'd mentioned this before in the proceedings that there's reasons why you might want to count. And take a look at the statute cited there. And back to that. Section 736.1008. If you provide full accountings, full disclosure, and there's something that's in that accounting covered in those disclosures, and they've been fully informed, the beneficiary, it shortens the time they can bring an action to 6 months from the date that they were served that. There's a notice you have to put on that advising them of that, and there's some statutory language you can get from the statute. That's a significant shortage of time and a little bit more surety to the trustee as to when they could get sued. So that's one of the reasons, even if you don't have to account every year, if they waive it, you may want to account and take care of this and take advantage of this section and shorten your time to have them bring an action against you. And also just be aware there is some common law out there that if a beneficiary interested party specifically consents after being fully informed to action, they can't later sue for breach of a fiduciary duty, even if they consented to the action, knowingly consented. Now, in the last few minutes, let's talk about guardianship litigation. Guardianships are when we are dealing with an incapacitated person, either due to age or mental infirmity. Common litigation pitfalls for a guardian. Conflicts of interest is a big one. If you're going to be a guardian of a person, oftentimes it's a loved one, and if you're trying to spend their money or make decisions for them that ultimately benefit you to the detriment of maybe another future beneficiary, or that is to the detriment of the person. If you're not giving them the care they need, or if you're not buying them the things they need because you want to save the money for you as a beneficiary, that's a conflict of interest. And if you're taking action like that, you can get in trouble. You have an absolute duty to make decisions that are in the best interest of the ward, the person that you owe the duty to. You can take advantage, like the probate, petition for an authority to act. If there's any questions about what you can do or should do, petition and ask the court. Accountings, it's actually necessary in guardianships to account every year to the court, and the court actually has workers that review this. This is something I think is underused by litigators too in the context of guardianship litigation. Judicial interim review, section 744.3715 Florida statute. It provides a mechanism wherein any interested party can seek by a petition the court's review of a guardian's conduct to determine if that guardian has exceeded their authority under any approved plan or court order. So at any time during the process, if you have any reason to believe that the guardian is acting outside the scope of their authority or have abused their power, you can bring this up and have evidentiary hearing on same. Real quick, in the last minutes here, just take a look at how a fiduciary can become personally liable. I've laid out the sections that provide for this in short form. Usually a personal representative trustee is not going to be liable for conduct taken in their capacities when it relates to contract claims, as long as they signed and or disclosed that they were entering into that contract in their fiduciary capacities. They're only going to be personally liable for torts, usually when they're personally at fault. That there's some exceptions and those that you'll read in the statutes, but that's the easy way to remember it. Surcharge against fiduciaries and other interested parties. If the fiduciary is also a beneficiary and or has received fees for their fiduciary work, the court can take what they call surcharge, take their fees back or take their interest back, and make things right. That's all the time we have here today. I've appreciated going over this, what sometimes looks like a complicated area of the law, but it's one that's actually really fascinating and it has its own unique quirks. Thank you again for your time and have a good afternoon. They're only going to be personally liable for torts, usually when they're personally at fault. That there's some exceptions and those that you'll read in the statutes, but that's the easy way to remember it. Surcharge against fiduciaries and other interested parties. If the fiduciary is also a beneficiary and or has received fees for their fiduciary work, the court can take their what they call surcharge, take their fees back or take their interest back, and make things right. That's all the time we have here today. I've appreciated going over this, what sometimes looks like a complicated area of the law, but it's one that's actually really fascinating and has its own unique quirks. Thank you again for your time, and have a good afternoon.